Cameron Miller and Taylor Young. I see a Taylor and I see Mr. Miller. All right, good morning.
Good morning.
Ms. Taylor, were you asking for a continuance earlier?
Yes, I didn't receive.
Ms. Young, I guess. I'm sorry.
Yes, I haven't received like the paperwork itself, and so I don't know exactly what I'm going against. And I also would like to get an attorney because this has been going on for far too long. And my dad just passed away, and so I've been dealing with that this week, and I did not have time because I just got the little piece of paper in my mail the day before yesterday. And so I got to go to USPS and get the paperwork, I guess. All I got was the thing, but I didn't know that until I checked my mail.
Mr. Miller?
Can you hear me, Your Honor?
I can, yes.
Okay, so I want to put it on record that Miss Young's packet actually was delivered on February 25th at her mother's house. Her grandfather signed for it. And we're here because she hasn't been paying child support, and she wanted to take it upon herself and to collect the taxes on a child that she has not been providing for over a year. So
Your Honor,
I'm not finished.
We're not going to talk at the same time. Mr. Miller's turn. Go ahead, Mr. Miller.
In that I called all the right people, meaning like the IRS and all that, and they're doing an investigation on it because now it's tax fraud, because I have full custody of the daughter. Okay. I have full custody of her. The daughter lives with me. She goes, if you got something to say, Taylor, let's say it, because I'm not done.
So I can speak.
Just a minute. We're not going to talk to each other. Okay. You direct everything to me. And the question right now is whether I should put this over a week or two.
I would ask not to, because she has been properly served.
No, so I haven't. My mother.
Just,
oh my gosh.
Let Mr. Miller finish, okay? And Ms. Young, if you speak out of turn again, I'm going to mute you. Okay.
She does. I have the paperwork of her grandfather signing for it. I turned that into the courts and all of that.
Okay, let me tell you. I'm going to accept it was served on February 25th. That still is not enough time for someone to respond. That's, I think, only 5 days, and that isn't enough for someone to respond. So based on that, on just that alone, I think a continuance is warranted. And you're bringing a motion for contempt. Really, nothing's going to change between now and a week from now or 2 weeks from now. So, Ms. Young, how long do you want to put this out?
I have a meeting with the cremator on Monday, but I'm meeting with an attorney next week. Okay. I talked to them already, and they're going to represent me because we've been doing this too long. And
okay, let's then go out 2 weeks to March 16th.
Okay.
And this is usually Commissioner Cotterell's docket, but if I happen to be on this docket in 2 weeks, I will expect everybody to be ready to go forward at that time. Okay.
Thank you so much.
All right. Thank you, Mr. Miller.
Thank you, Your Honor. Have a good day.
Yep. Next is Cameron Miller and Taylor Young. I see Mr. Miller's here.
I'm here, Your Honor.
Diane Lefker, limited license legal technician with Ms. Young, Your Honor.
Okay, thank you. I need to bring up two things. First of all, Mr. Miller had submitted a motion for default in this case that I got several days ago. He did that ex parte. I didn't sign it because Ms. Young has been participating in the case, and when she appears, she first of all is entitled to notice of that. But I think her failure to file a formal response is at this point an oversight. She clearly wants to be involved in this case. So I'm gonna set this out to March 30th, not the whole case today, but just the default portion of it. I'm gonna set out to March 30th for Ms. Young to file a response. And if one is not filed by then I may enter a default, but I'm not gonna do that today.
Yes, Your Honor, we'll get one filed right away.
Okay, what
Since
we're
I just
here
came in.
about today is a motion for contempt that Mr. Miller has brought. And so, Mr. Miller, I'm gonna ask you to argue that case first. You'll be the first one, and then Ms. Young, you'll have a chance to respond. And then Mr. Miller, you'll have a chance to respond to Ms. Young, and then I'll make a decision on that. Okay. So tell me why you feel a motion or an order of contempt should be.
Because Miss Young has obligations to her daughter and she's not fulfilling them at all. She's had multiple opportunities to reach out to help with everything and she hasn't done that. Taylor's about Taylor. Taylor doesn't care about her daughter or fulfilling needs for her daughter or trying to help her daughter. Taylor doesn't even have a job, for one, so she really can't support herself or her daughter. And, you know, I've been supporting Malaya now for over 2.5 years, okay? And she's been living with me. And I also want to put on the record that that packet that Miss Young turned in, completely false. For one, she doesn't state, and the sad thing is that she has an attorney that's helping her. The attorney can't be that smart because she doesn't ask the simple questions of the facts of, oh, me and Miss Young were together. No, me and Miss Young haven't been together for over 7 years. For all you know, Your Honor, you know, we just got done last week in a relationship. False, okay? The other thing is with child support contacting her, Miss Young says that they haven't. False. I just got a letter in the mail yesterday stating that they're asking me how to get a hold of Miss Young. How do we find Miss Young? Because Taylor does not respond. Miss Young does not go in to the post office and collects her packets that, you know, I turn into the courts. I send to her mother's house. I send to Miss Young's house. I have officers try to serve Miss Young. Taylor does not care. And quite frankly, I'm done. If she wants to go play around with some lawyers, well, I'll go get a big time lawyer too, and it will be done. Because like, I'm not about it for me no more. It was never about me. Like, Taylor is about her. This is about my daughter and what my daughter needs and what my daughter deserves. My daughter doesn't deserve somebody who does not care about her well-being or care about her needs or cares about her financial areas or where she's living or what, you know. I'm done. I'm ready to get it done and move on. That's all I got to say.
What are you asking the court to do?
Hold her in contempt because she has not done what she is supposed to be doing.
And what I understand from your motion, you've indicated she hasn't provided school clothes. Is that right?
Correct.
All right. She quit her job.
Correct.
She did not follow the parenting plan by administering the medication.
Correct.
Okay. You indicated on 6 occasions that you've determined she did not give the medication to Malaya.
Malaya.
Correct. Okay. Okay. Thank you. Ms. Young, would you like to respond?
Yes, actually, Your Honor, I do have a job. When he went for child support, I was a jack in the box and I got a new job. He just didn't know that. I am fully employed. I have lived in my apartment for a year now, and I do take care of Malaya. The problem is I'd send her with clothes and stuff and they wouldn't be returned. So I would constantly be buying her new stuff. I asked for them to return her stuff and they refused to. So I stopped sending her home with clothes because they weren't being gave back to me. And so I said, okay, then when she's with you, you have her clothes. When she's with me, I have her clothes. I've never kept anything from her. I've never not taken care of her. Cameron keeps her from me. All these things he's saying he's doing. I want to be in my daughter's life 100%. He refuses to let me. And he hasn't always provided the medication. I have text messages of us trying to get her meds and he refused to give them to me. I already didn't feel comfortable with him. So we went for my grandfather, my mother, my uncle. We were all willing to get the medication and he refused. And then they just didn't respond. Then there's also message where Samantha said that it's okay for her to not have them for 2 days. She'll be fine over the weekend when they forgot the meds. So now I'm under the impression, so it's okay for them to forget meds. But when I did not give them to her one time because she was having a mental breakdown. And I told him that. I was like, she told me that they forced them down her throat. I wasn't going to do that. So I didn't give him to her that morning. Correct. But other than that, I do give him to her. We talked to my stepmom on the phone. She helps us. She hates them, but she definitely takes her medication. It's true, I don't agree with it, but she does take her medication. And he hasn't had her the last 2.5 years.
Are you willing to follow doctor's orders on the medication?
Yes.
Mr. Miller, any response to?
Yeah. Oh yeah, I got a response. Okay, so that medicine that she's just now talking about, where they try to contact us to meet up with us, she's lying, okay, under oath again, because when I originally put all of this paperwork in, that's when Taylor kept my daughter from me for 3 weeks. 3 weeks. That's at the beginning of all of this, Your Honor. That's in black and white paper. Because that's where the restraining order came into play. That's how I got the restraining order on Taylor and with Malaya because of child neglect. Okay, that's how that happened. And I don't keep my daughter from Miss Young. When we first broke up in 2016 or 15, when Malaya was 3, Taylor was the first one to play that keep away game. I don't play the keep away game, okay? And Malaya has lived with me for 2.5 to 3 years. I've already been in Cowlitz County for 2 years. I've lived with Malaya at my girlfriend's house, at her father's house in Napa Vine, Lewis County for a year with my daughter. That's 3 years running, going on 3.5 now, okay? Malaya has gone to school down in Cowlitz County for 2 years. My timelines are adding up. Miss Young is completely wrong, okay? Her attorney is not asking her the right questions, it doesn't seem like. The other thing is, what else was it? What else did she say?
Does Miss Young see Malaya now?
Every other weekend, because you guys, as your courts, ordered that. There was the other judge, the other male judge who was doing our case. That's why he offered every other weekend, is because he felt as though Taylor was putting Malaya in harm's way. He granted my no contact order. He granted everything because I came with the right documents. I'm doing what I'm supposed to be doing. And quite frankly, on docket, I'm not lying. Miss Young, under oath, is lying to the judge and to her lawyer. Flat out about it. And Miss Young knows she's lying. That's the sad part. Because if I was lying, I wouldn't have a solid case. I wouldn't have a solid case at all. And I'm pretty confident that my case is solid.
Okay. The other judicial officer was Commissioner Cotterell, who
Yes, Your
did
Honor.
those
Him.
orders. All right, I've looked at the file and at the motion. Mr. Miller has brought a contempt motion indicating that Ms. Young has not provided school clothes, that when she was
That's what it was.
to support Malaya, she quit her job. She hasn't followed the parenting plan, and a particular concern is that she has not given the ADHD medication. And as she indicated here, she doesn't agree with that, but she disputes whether the indication that she did not give it. I'm going to deny the motion at this point, and the reason is I did not see a child support order in the case, that there's no specific order relating to medication. She's given, I think, joint authority over healthcare issues, but to read that to mean that she absolutely has to give certain medications, I think that would be overly broad at this point. There's no tax exemption order, and there's nothing in the temporary restraining order about contact through third parties, which was another issue. So what the reason I'm denying it is I don't think there's any orders that require what Mr. Miller says should have been happening. I do think Mr. Miller's order does raise issues that should be clarified going forward. Okay, so I'm going to do that so that everybody is on the same page at this point. So first of all, if a physician has ordered medication, whether it be ADHD or any medication, then Malaya is to be given that medication, whether she's with the father or the mother. Okay. And if from this point on, there's evidence that Ms. Young is not providing that medication, then that would subject her to a contempt order. Okay. I'm going to allow, this was not clear, but I'm going to allow contact through third parties between the parties. I think a lot of times I will indicate that a protection order or restraining order prevents somebody from contacting the other party directly or indirectly. So that would include third parties. But here there needs to be some way to communicate regarding the transfer of the child and other issues. So I'm going to allow contact through third party. And finally, there were issues, comments made about disparaging remarks made to the child regarding the other parent. I'm going to prohibit that being done in front of the child. That the parties, the parents cannot, for lack of a better term, badmouth each other in front of the child going forward. Okay. So those are the three things I'm going to put in place today. I'll do a bench order to that effect.
Commissioner, can I add one thing, please? Can you, with the medication that's a controlled substance, such as the ADHD medication, that father is required to?
I'm not required to give you guys that information. No, I am not.
Let her finish. Okay, Ms. Lepker, go ahead.
Thank you. That he is required to provide that medication for mother's visits. And if he doesn't, then he needs to make arrangements to get it to her in order for her to give the medication.
Okay, so I do send my daughter with medication. You should probably ask your person right there that when that was, when she decided to take my daughter out of her home 3 weeks prior to school. You must not be that good of an attorney.
Okay, so
I need to go. I need to go, please.
I'm going to add that if you expect, well, if the doctor has ordered medication and it needs to be administered during Ms. Young's visitation, that will be provided to her.
It is provided with my daughter to Malaya every other week, and my daughter goes there.
I'm not deciding that or even disputing that. I'm just saying that's going to be part of the requirement going forward.
Okay, and I want to put on record that I am not required to give the name of the medication to her mother. I'm not required to do that, and I'm not required to let Taylor go to Malaya's doctor's appointments. I'm not required.
I don't know if that's true. What I believe I saw
There's
the
the
parenting
restraining
plan.
order. How is she supposed to go with the restraining order? That don't work.
Well, that may prevent it, but I think the parenting plan does not prevent that.
No, you're right.
Okay. All right, so I'm going to enter these orders as we've discussed.
I got one more question.
Go ahead.
Where's her attorney practice at?
Her attorney is what's called a limited license officer who, you can look it up. Ms. Lepker, do you want to disclose where you practice?
I have. He's already received my documents, but I practice with the law firm of Andrews, Terry, and Jeffers in Vancouver. And I'm happy to send you over
I already
information. Okay, thank you.
Okay. All right, I think that's it for today. Thank you, everyone.
Thank you, Your Honor.
All right, let's call the Cameron Miller and Taylor Young matter. This is cause number 22-3-36908. See Cameron Miller's on the line. Can you hear me, Mr. Miller?
Yes, Your Honor.
Okay, great. I can see you. And then I'll ask if Taylor Young is on the line. Taylor Young, are you on the line today? All right, Ms. Young, I'm not hearing you. If you are on the line, please unmute and state your name, please. Taylor Young. Okay, so I'm not hearing any response from Ms. Young. So it looks like, Mr. Miller, you filed, looks like several motions. One is a motion for a default. Second is a motion to amend a parenting plan. Third is a motion to amend a restraining order. And one thing I need to double check is the service. You've heard me talk a lot this morning about service. So let me just take a quick look at the file, make sure we're good there. Okay.
Hey, I'm almost done. We're on me right now.
Okay, so it looks like your motion, Mr. Miller, I'm seeing your motion for default was entered. Looks like you filed it back in September of 2022. Does that sound about right?
Correct.
Okay, and we had a hearing in September. There was some concern about service issues. Okay, I've got my notes here, so let me take a quick look at this. So looks like Ms. Young was served that motion for default, or she was served on the 26th of August of last year and also served on September 6th. Judge Basher found that 90 days had not transpired because it was serviced by mail. So at that time, Judge Basher denied the default order because it needed to be a longer period of time. Then on September 22nd, both Mr. Miller and Ms. Young were present, and the judge entered a parenting plan at that time. and the mother has not filed a formative response or a formal response. And it looks like it was previously denied, and so we're back on. So was there so what I'm seeing, Mr. Miller, and I apologize for kind of talking out loud, is that there was that September motion for default that you filed. It was heard by Judge Basher. He denied it because the service time periods are longer when it's mailed, and the 90 days had not yet transpired. So he denied the motion for default. And so is there a new motion for default that's on the table?
I believe so.
Okay, great. So the clerk just looked at me and gave me that look and said, look in your paperwork. So I'm looking in my paperwork now. So thanks for your patience, Mr. Miller.
Oh, you're fine.
I do see it here, so let me take a look at this. All right, so here's the new motion for default. I've got it. Thank you. So I did look at this earlier, so let me review it again. All right, there we go. All right, so the motion for default basically indicates that you're making a motion to the court because you filed and served the other party on September 22nd with a summons and a petition. And that was at least 91 days ago, kind of what we were talking about.
Right.
And that you live here and she lives in Thurston County and the kids live here, or child lives here, and that she's not covered by the Service Members Civil Relief Act. Okay. And then did you give her a copy of, did you give her a copy or send her a copy of this motion for default?
Yeah, I believe we did it through email.
Through email? Okay.
Yeah.
All right. Let's take a look here. Mailing, okay. Bear with me one quick second.
Yep.
Let me ask you a quick question, Mr. Miller. It looks like you filed a notice of a hearing for April 13th. This coming in a couple of weeks. What's the purpose of that? Is that the motion to modify the parenting plan or amend the restraining order?
I believe so.
Okay, so
A lot of this is just happening so fast, and I'm trying to juggle this and juggle work all at the same time.
yeah, it's
And my
tough.
girlfriend, like, yeah. So I believe we're all on the same track.
Okay, so today we're March 30th, and then I see this notice of a hearing that says, hey, we've got a hearing scheduled on April 13th to talk about a motion to modify the temporary parenting plan and the amended restraining order, which I guess kind of makes sense because today you're asking for a motion for default to have the parenting plan and everything ruled with what you asked for because there hasn't been a formal response.
Correct.
And then we're coming back in 2 weeks to modify that parenting plan that we just entered today potentially and modify the restraint order. That's where I'm a little bit confused.
Okay, so there, can you still hear and see me?
I can hear you. I can't see you
Okay.
anymore.
Okay, so it's just to dismiss the motion for to default and go from there. Might bring up the motion the modify on the 13th for supervised visitations.
Okay,
Did you get that?
I think I got that because in your initial pleadings, you asked for a particular type of relief, and with a default, you can't change. Like, okay, now I asked for this, and I'm changing it. So you get
Right.
what you get what you asked for if you went on the default, and then if you want to change that, then you'd come back on April 13th to modify it.
Okay, yeah.
Is that what you're thinking?
Yes.
Okay, So that makes more sense to me after having you explained that to me. Let me just go on the initial motion here for your parenting plan. So here back on August 9th, you filed a parenting plan, a proposed parenting plan related to, is it Malaya?
Yes,
Okay. And it states that you're asking that there be limited decision-making, that you'd be in charge of school, education, and healthcare decisions,
yes,
and that you would be nominated as the primary custodian, and that she would have, Ms. Young would have visits on Friday at 6 p.m. to Sunday at 6 p.m. every other weekend.
sounds right.
Okay. And then you've got some holiday schedules set in there, and that the exchanges would be up in Toledo, a house up in Toledo. And so that's what,
It's
go
a
ahead.
truck stop, but yeah,
Oh, CG's.
yes.
Gotcha. Okay. All right. So that's what you're asking for. Okay, good. I think, thank you for your patience and helping me work through that. I appreciate that. Okay. Mr. Miller, has Ms. Young appeared at any of the hearings since the case has been filed?
Yeah,
So one thing that I was looking at on your proposed order for the default, it says, it's talking about notice for Ms. Taylor or for Ms. Young. It says the other party, Ms. Young, is entitled to notice of this motion for default because she appeared or was served with the summons more than a year ago, which I don't think that's accurate because it's not been more than a year. So the other option is that she's not entitled to notice of the default motion because she hasn't filed a notice of appearance and she has not appeared in this case in any other way and was served with the summons and petition a year ago. So I'm a little bit concerned that since she has appeared in the case, usually a default is like the other party says, whatever, or they don't contest what you're asking for. And so they don't show up for anything and just say that what that person wants, I'm okay with that. Here where she's,
I
go ahead.
I think she was kind of, I think more kind of explaining like she hasn't responded to the case, so like she's not there.
Right, she hasn't formally responded.
Right. So I think that not more or less like she hasn't showed up to the case, just more or less like she hasn't responded. Like she
Right.
showed up to court multiple times, but just never responds.
Right, right. And it looks like the contempt issue has already been decided. So we don't need to decide any contempt issues today because that was decided back on the 16th
Right.
of March. Okay. All right, bear with me one moment. Have you, that when we're talking about that hearing on the 16th or on the 13th, did you send her a copy of that notice for the hearing on the 13th?
Yes.
Okay. And then did you send her a copy of today's hearing or a
I
hearing
did.
notice of that?
Yes, I did.
So the one thing, Mr. Miller, I'm inclined to grant the motion for default if I have a showing that she was given notice of today's hearing. Do you know if if you filed some type of proof of service?
Well,
Yeah.
so like, was this hearing scheduled from the last court date?
Good question. Let me check.
Because if that's the case, then she was most definitely aware.
Okay, yeah, let me look. Last hearing was on March 16th. So I'll pull up the minutes from that date. She was present, you were present. And the court set the default hearing over to today at 9 o'clock. Court denied the contempt, rules on medication, third-party communication, disparaging remarks, sign a bench order. So that was done. And she was present and we set over the default to today. There was quite a bit of discussion at the last hearing about the default. And she was present with the limited legal technician, Ms.
Yep.
Balcher.
Yep.
And the court set the default out to the 30th today. And then y'all talked about the contempt, not providing school clothes, visitation, Commissioner Cotterell, child support. Okay, so all that. And that set it over for today. And usually when a case is set over, the parties are present and there's an indication that this case is going to be discussed today and that something would be filed. So I'm going to say that there was
She
notice.
was aware.
Yeah. I think that's true. So. Go ahead. Okay, let's see. Thank you. Thanks. Mr. Miller, the clerk kindly pointed out to me that on March 27th, it looks like Ms. Taylor filed a response to the parenting plan request. And she indicates that there's agreement in some portions and there's disagreement in other portions of the proposed parenting plan. So
Right.
I think that puts us at a position where that since she's responded, the motion for default is, I think I need to deny that since she filed a formal response. We still have the hearing set on this coming 16th or the 13th, I think it is, yeah, the 13th, to address the parenting plan.
But I mean, she's still not here today.
She's
So
not.
that's now we go back on that question of you asking me, like, what do I mean by how she's not present in court? This is a good example of how she's here, but she's not here.
Right. There's
If
kind
you
of
know
a
what I mean.
pattern of not being present.
Right.
Yeah.
So I mean, like, and that's what I've been fighting this whole time.
Mm-hmm.
That's why my end is being prolonged.
Yes. Yeah. And I can't disagree with you. I think here that you know the fact that somebody doesn't show up to court is somewhat frustrating. With the default, it's a little bit different because with the default, basically there's not a formal response, and that's what the court's looking at. Because sometimes people just say, I don't care, do whatever you want, get whatever order you want, and then the court do that. But that's not the case here. So she's filed a formal response which says, okay, there is something in dispute that the two parties have divergent views on what should be the outcome of the case. So since she's filed that, and it would be very good if she were here, but she's not. So I think that's enough to deny the motion for default, simply because the court looks for at least some formal acknowledgement that there is a dispute or there's not a dispute. She's saying there is a dispute. Okay, so that means the case goes forward. So if with the docket notice sent out for the 13th, then we'll be here on that date to consider the motion that you filed.
Okay, I want to put on the record that she was not here today, though.
Yeah, clearly. Yeah,
and it follows a pattern of her.
yeah.
Okay.
Yeah, that's fine. Yeah,
Okay.
the clerk's minutes they always reflect who's present and not present. It'll reflect that Mr. Miller was here, is here, and Ms. Young is not here.
Okay.
Notwithstanding the notice that she had that we were going to send it over to today, she's not present.
Sounds good to me. But so nothing's changing though on my end.
Right, as far as the motion for,
until the 13th.
right.
Okay.
Yep, that's I think that's an accurate portrayal.
Okay.
Okay. All right. Thank you, sir. We'll see you in 2 weeks.
Thank you, Your Honor. Have a good afternoon.
Take care.